want to touch on one more topic in this lecture, and that's the question of affirmative action. Affirmative action, of course, is typically done to achieve either race or gender balance in various industries where there has been discrimination traditionally in the past. And affirmative action, of course, raises some interesting questions, because if racial classifications are supposed to be subject to strict scrutiny and almost always found to be unconstitutional, what has the court said about those things? Affirmative action was instituted in the 1960s, and one of the more famous statements about the need for affirmative action and the sort of the spark that led to affirmative action being adopted in the country was a speech that President Lyndon Johnson gave to Howard University, in which he explained the rationale for instituting these programs.
But freedom is not enough. You do not wipe away the scars of centuries by saying now, you are free to go where you want, now do as you desire, and choose the leaders you please. You do not take a person who for years has been hobbled by chains and liberate him, bringing up to the starting line of a race, and then say, you are free to compete with all the others, and still justly believe that you have been completely fair. Thus, it is not enough just to open the gates of opportunity. All our citizens must have the ability to walk through those gates. And this is the next and the more profound stage of the battle for civil rights.
So those are wonderful sentiments, but they certainly raise a constitutional problem, because as we've already seen, discrimination against women and minorities almost always fails the strict scrutiny test. So the question that many ask is, why shouldn't discrimination in favor of women and minorities also fail the strict scrutiny test? Isn't discrimination no matter what form it takes? And that's the question that the court has dealt with. And the interesting thing is, the first major case in which the Supreme Court dealt with the issue of affirmative action was Bakke v. Regents of the University of California back in 1978. And it was a highly divided court that established the principles of affirmative action that continue through to this day. Although the court was very divided, the principles established in Bakke still persist right here into 2020. But as we'll mention in a little bit, that era may be coming to an end very soon. But let's talk a bit about Bakke. So Bakke came from right here in Northern California, from the UC Davis Medical School, who back at that time every year had 100 slots that were available for students who wanted to attend their medical school. But as part of an affirmative action program, 16 of those slots were specifically set aside for members of racially and historically disadvantaged groups. So if you were a white student, you could compete for 84 of the 100 slots. If you were a non-white student, you could compete for all 100 of the slots. Alan Bakke was an applicant who was white, and he applied and obviously was denied admission. And when he did some investigating, hired an attorney, he discovered that the test scores and many of the other objective indicators of academic excellence were higher for him, for Alan Bakke, than for all 16 of the students that were in the 16 slots that were set aside for racial minorities. And so he argued that this violated the Equal Protection Clause of the Constitution and did not meet the strict scrutiny test. The court was highly split on this issue. And it's just very interesting because they were so split. 4 of members of the court were very conservative, 4 members of the court were liberal on this issue, and then there was one member in the middle who kind of split the difference, and that one member made all the difference. If they had joined with the conservatives, or if they had joined with the liberals, the law of affirmative action today would look very different than it does, but they didn't. And so we're where we at. We're where we're at. So let's take a look at what did the court say in this particular case. Well, again, the court was split. You had 4 conservatives on the court, or at least 4 justices who took the conservative position in this case, and they adopted the traditional conservative stance that race can never be used as a factor. Racial discrimination is racial discrimination, and this did not meet the strict scrutiny test. There was no compelling governmental interest, and this was certainly not narrowly tailored. On the other side, there were 4 liberals on the court who took the traditional liberal stand, who argued that yes, indeed, race can be used as a factor, just as President Johnson said. The history of racial discrimination and the current effects of racial discrimination, poor schools, poor neighborhoods, so on and so forth, put African Americans and others at a disadvantage, and therefore we must take race into account in order to address the problems that have been created by racial discrimination. And so they would have voted to uphold the University of California's scheme. But neither one of these sides got everything they wanted, because in the middle was Lewis Powell. Lewis Powell was a quintessential swing voter on the court during his time on the court, and that was definitely true in this case. Lewis Powell's opinion ultimately decided that the University of California system was illegal and unconstitutional because, he said, it represented a quota. He said that it was unfair that there were 16 spaces that were specifically for minority applicants that white applicants had 0 chance of getting, and that this was a numerical certainty. There was a guarantee that at least 16% of the class would be members of a particular race, and that this kind of numerical certainty was a quota, and quotas are unconstitutional according to according to Powell. And so this part of his opinion was very favorable to the conservatives. The conservatives on the court agreed with him, and they joined this part of his opinion. So you had 5 members of the court who agreed that quotas are illegal, and since the UC program constitutes a quota, it is therefore unconstitutional and must be thrown out. However, Powell did not stop there. If he had stopped there, the conservatives would have simply won. Powell went beyond that, and he had some things to say that adopted the liberal point of view. Powell said that race cannot be used as a quota, but it can be used as one factor among many in hiring decisions, admissions decisions, contracting decisions, and other decisions by government. And by the way, I just want to point out, of course, that we're still talking about public discrimination in this case, because we're looking at the University of California, which of course is a state university. It's a government-run university, and so it is bound by the dictates of the 14th Amendment. So according to Powell, quotas are illegal, but race can be used as a factor, or gender can be used as a factor. Powell said that there is a compelling governmental interest in higher education. Diversity is an important value for institutions of higher education, and that is a compelling governmental interest. And although quotas are too broad, quotas are not narrowly tailored, race can be used as a factor, because there are many factors that go into evaluating applicants to a university, and race can be one of the considerations because of the value that it brings to racial diversity and how that can enrich the educational experience. So the court kind of straddled a line here, and did allow governmental institutions going forward to use race and gender as long as they were not very strict in doing so and have specific seats or specific benefits set aside in guaranteed numbers for one group or another. Now, one thing that occurs often is that when people talk about affirmative action, they sort of blend together or bleed together three different forms of affirmative action that have different levels of legal sanction. One we've already talked about are quotas, and as we've mentioned, the Supreme Court has declared those to be unconstitutional. That's been true since 1978, and so quotas are not a legitimate form of affirmative action. One form of affirmative action that is constitutional in almost all situations is enhanced outreach. Oftentimes, and you're probably familiar with this in your own jobs, if you have a job opening, of course, you want to make sure that you have a diverse applicant pool, and you, of course, will not make your selections based on race, but you want to make sure that your applicant pool is diverse. And so the courts have certainly upheld the use of enhanced outreach, trying to go the extra mile to make sure that members of disadvantaged communities are aware of opportunities and are encouraged to apply. So, for example, if you have a job opening, it is permissible to take out ads in minority-owned publications or websites that may be geared toward minority professionals in your field. And we do that in the political science department when we hire individuals in the department. There are newsletters and listservs and other resources for women political scientists of various gender and racial and ethnic groups, and we make sure to reach out to them to let them know, in addition to the other ads that we run, that these jobs are available, and so we try to increase the diversity of our pool that way, and the courts have said that that is fine. There's a third category, and this is the one that's always kind of tricky, and that is goals and timetables. Affirmative action is always tricky because the only way you can know whether there's a racial discrimination problem, usually, of course, is by using statistics. Let's say that there's a city that's 80% African American and yet only 10% of their firefighters are African American. Well, that suggests that there might be a problem. But just because you use numbers doesn't necessarily mean that you need exact numerical parity. So just because you may have 80% African Americans in your city doesn't necessarily mean that 80% of your firefighters should be African American. But if there's a huge gap, then of course that may indicate that there's something wrong. The problem, of course, is that if you start using numbers, then the Supreme Court starts thinking you're talking about quotas. But the court has, in many instances, upheld what are called goals and timetables. Goals and timetables are kind of like quotas, but they're much looser. That's really only the way for me to describe it. So a city may say, well, we have a goal over time that we would like to increase minority representation by 30% over the next 10 years, or something like that. But as long as it's not held as a strict, requirement under the law, but just as kind of a loose thing to work toward, it's probably okay. But again, that will that'll depend on how the court reaches it and how strict they think that is. But in any case, you probably, in your own work, do use both of the latter two forms of affirmative action. So your textbook has a couple of cases that nicely illustrate, I think, kind of the court's approach to this. And both of these cases, they were decided by the Supreme Court on the same day. Both of them involve affirmative action programs in institutions of higher learning and universities. And in one case, the Supreme Court upheld the affirmative action plan, and in the other, the court struck it down. And so I would ask you to take a look at these two cases, take a note of what's the difference in the two programs and the way that they worked, and why did that result in the difference in the Supreme Court's opinions and decisions in the two cases, and also take a look at what they have to say about whether or not there is a compelling governmental interest and whether these plans are narrowly tailored. One of the plans obviously passes both tests, the other does not, and if you can figure out why that is, then you probably have a pretty good handle on this whole field of affirmative action and equal protection generally. Well, as I've indicated, in 1978, the court kind of split the difference. It said you can't use quotas, but you can use race as a factor. But that is, or it may be, changing very, very soon. Although Lewis Powell left the court, his replacement was a guy named Anthony Kennedy. And Anthony Kennedy was a lot like Lewis Powell in that he too was a moderate. And on affirmative action cases, he generally adopted Powell's moderate approach. So for about 40 years, the sort of balance or the compromise between liberals and conservatives on affirmative action has held. But as you probably know, Anthony Kennedy is now gone from the court. And the court is now divided into, there are no moderates on the Supreme Court anymore, and although we have not seen what Brett Kavanaugh and Neil Gorsuch had to say about affirmative action, we can bet that they probably agree with justices such as Clarence Thomas and Samuel Alito, who argue that there is never a compelling governmental interest in achieving racial balance. That is something that they reject. And so, as a constitutional matter, if you believe that there is no compelling governmental interest in achieving racial balance, then that means affirmative action programs are always unconstitutional. And although, again, the Supreme Court has not ruled on this issue since Brett Kavanaugh joined the court, it seems pretty clear to me that the next time they do, they likely will reverse Bakke, or at least gut it so substantially that it will mean nothing. And I anticipate that affirmative action will probably be declared unconstitutional outright in all forms by the Supreme Court coming up within the next year or two. Now, in some respects, California is ahead of the curve. California, of course, is a liberal state, but up until about 10 years ago, it used to pass a lot of conservative ballot initiatives. And back in 1996, Californians passed Proposition 209. I don't think this would pass today in California, but it did back in 1996. And Proposition 209 ended affirmative action in the state of California. Now, that's probably not as meaningful as you might suggest, but it certainly did affect higher education, which universities in California were required to come up with new ways of trying to achieve a more diverse student body without any consideration to race. And one of the ways that they did that, for example, was often accepting the top 3% or the top 10% of every high school in the state, and doing other things that are designed to try to achieve diversity without specific reference to race. Now, Proposition 209, at least for a while, was interesting because it did result in a decline in minority admissions at UCLA and elsewhere, but those have bounced back. Well, we have been spending our time talking about public discrimination to this point. Once again, that's discrimination by the government. What we haven't talked about is private discrimination. So let's talk about that in our next lecture.